Hi, everyone. Thanks for joining us for this installment of Business Break. We hope you've been following along in this series to get some practical, informative legal information about your business. I'm Tess Layton, and my colleague Jeff Daniels and I will be providing you with the next series in this webinar, which is Business Break Annual Obligations for Corporate Governance. So there are many perks of operating your business through a corporation, but with those perks come some annual obligations and filing requirements, which are necessary to keep the corporation in good standing. The purpose of this very simple, quick presentation is to provide an overview of those annual requirements that apply to Alberta Corporate Registry to ensure that you maintain your minute book and to ensure that you maintain in good standing. So today we're going to be talking about annual filings, meetings, consequences, and registered office. The Business Corporations Act imposes certain mandatory obligations on corporations, including annual filings with corporate registry and mandatory meetings. So we'll discuss how failing to meet those ongoing maintenance obligations can result in fines, involuntary dissolution, which essentially means you'll be struck from the corporate registry, and other consequences. We'll also talk today about how some of those meetings can be done by way of resolution and how you can maintain your corporate minute book at a lawyer's office in order to take some of that burden off your business. So for annual filings, a corporation is a separate entity from the individuals controlling it, and certain filings are required to keep the corporation in good standing. Probably the most important of these is annual returns. Failure to file an annual return can result in your corporation being struck from the corporate registry. So to keep a corporation valid and subsisting, annual corporate returns must be filed, and some resolutions need to go along with that. The annual return confirms important details about the corporation, including its address, current shareholders and directors, and whether or not there have been any changes to the corporation that need to be updated with the registry. In Alberta, that would be directors or shareholders and officer information. Failing to file an annual return for a period of 18 months in Alberta will result in the corporation being struck. So generally speaking, this is quite a long time, but many things can happen in 18 months. And of course, it's easy to get behind. Whenever there's changes to a corporation, that needs to be filed and updated. If it's done at the same time as the annual return, such as at the annual general meeting, it's a good time to make sure that your annual return encompasses all that information so multiple filings don't have to be done. Whenever there's a name change or a director's change or an office change, what we do is we file a notice of address or notice of directors, as the case may be. Failing to keep the corporation updated of your current address, for example, whether that be your head office address or your lawyer's address, can have serious implications if you're ever sued. For example, if someone files a statement of claim and serves it on your registered address and that information is outdated, you may not actually receive that information until the limitation deadline to file a defense has passed. With respect to taxes, a corporation must file corporate tax returns annually. Your accountant can help you out with what your tax filing deadline is and the obligations that go along with that. Another important thing to keep in mind with respect to annual filings and annual obligations is your minute book. So a corporation is required to keep and retain corporate records, including articles and bylaws, meeting minutes, and resolutions of shareholders. Copies of financial statements are also included, and any unanimous shareholders agreement that's applicable to the corporation also goes in the corporation's minute book. Failing to prepare and maintain mandatory records is an offense and can result in a fine of up to $5,000, which is pursuant to the Business Corporations Act. Keeping a complete and organized minute book can really save time and money, especially because the effort that it takes to go back and actually recreate all of these records is often more than if you were to just do the annual minute book updating on an annual basis, either yourself or through a lawyer's office. Another important thing to note is that our office can prepare virtual minute books or e-minute books. This is really helpful for you because if you go to a bank and you need a loan, you need to open a business bank account, or you're entering into another transaction where your corporate documents are needed, we can provide those documents and that information fairly quickly to whoever you instruct us to give it to. Like I said, annual returns can be done by a law firm and your minute book can be maintained by a law firm, or you can do this yourself. But the most important message here is to make sure that it's done in an expeditious way and on an annual basis. Meetings. So meetings are a very important function of a corporation. The Business Corporations Act, of course, mandates that annual directors' meetings must be held and annual shareholders' meetings must be held as well. Meetings can be held by way of resolution in lieu of an actual physical meeting. So at annual directors' meetings, the directors will appoint or confirm the officers and will approve the corporation's annual financial statements. A resolution signed by all of the directors entitled to vote at the meeting can take place instead of an actual in-person meeting. This is important to note in times like COVID-19 pandemic times, because of course you can ensure that you're complying with the Alberta Business Corporations Act through passing resolutions with unanimous consent, rather than meeting in person to actually conduct a meeting where social distancing requirements may not be able to be met. I spoke a little bit about annual financial statements, and directors of a corporation are required to ensure that annual financial statements are prepared and that those financial statements are provided to the shareholders. The financial statements must be approved by all of the directors and provided to those shareholders at least 21 days before the annual general meeting. Directors are also required to place before the shareholders the aggregate remuneration paid to directors and the 5 highest officers, employees of the corporation. The annual shareholders meeting is also a requirement. The directors of the corporation must call an annual meeting of the shareholders within 18 months of incorporation and within 15 months after the date of the last annual meeting. At the annual meeting, the shareholders will approve the financial statements, they will elect the directors for the ensuing year, and they will appoint an auditor or accounting advisor. All of the meeting minutes and the resolutions should be organized and kept in the corporation's minute book. All of the shareholders entitled to vote and to receive annual audited financial statements in advance of the AGM, unless the requirement for an auditor is waived by resolution each year, they should receive that information within an applicable time period, and obviously that gives ample time to review it. Resolution signed by all of the shareholders entitled to vote satisfies the meeting requirement. So again, a very useful tool during the pandemic. You can meet with your shareholders and pass a resolution in writing instead of an actual in-person meeting.
So Tess provided an overview on what is required to maintain your corporation, but why is it important? I'm going to discuss briefly a few different consequences that can result as a failure to properly maintain your corporation. As was mentioned earlier, failing to file annual returns can result in your corporation being struck from the corporate registry. When a corporation is struck, it no longer has a separate legal existence. What this means is that the corporation can no longer enter into contracts, own lands, and then the principals behind the corporation could potentially lose the liability shield and the tax benefits that the corporation affords. A struck corporation can be revived on an application to court, but it's best to avoid this altogether. Failing to maintain adequate records and have them available to directors and officers can result in a fine under the Business Corporations Act of up to $5,000. There can also be disputes that arise from improper record maintenance or disputes that escalate because of improper record maintenance. For example, shareholders are entitled to receive audited financial statements. If this entitlement isn't properly waived in the annual shareholders' resolutions, a shareholder could come back after several years of not receiving audited statements and request these, which could cost the corporation a lot of time and a lot of expense. There are also many other challenges that can result from improper maintenance, including challenges with borrowing money or selling the business when it becomes time to do so. Potential lenders, banks, and purchasers will often want to review corporate records as part of their due diligence. If the records are not well kept, it'll make their review process more difficult, and it may reflect poorly on the management of the business. Finally, we're going to discuss registered offices. Using a law firm as your registered office does have some perks. The law firm will have a system in place to ensure that annual returns are prepared in advance and filed on time. This will ensure that your corporation does not get struck from the registry. and you do not lose that benefit of having a separate legal entity to operate your business. The law firm will also maintain your corporation's minute books. This will be done either in hard copy, electronically, or both. And as Tess mentioned earlier, access to your corporate records will never be an issue because your law firm will have those readily available to provide to you or to provide to any party requesting them on your behalf. Finally, when a corporation is sued, there's only a short time to file a defense. Under the rules of court, a plaintiff is able to serve a lawsuit on the registered office of the corporation. Having a law firm act as your registered office will ensure that the lawsuit is received and greatly reduces the likelihood that an important deadline to file a defense would be missed. For example, if the principals of the corporation use their home address as their registered office and are away on holidays, it could be easily seen how a 20-day period to file a defense would be missed. So that concludes our content for today's webinar. This presentation was geared at giving you a basic overview of annual maintenance obligations of a corporation and some of the consequences that can result if maintenance obligations are ignored. We hope this helps make your business a success. And if you have any questions, please give myself or Tess a call. Thanks for tuning in.
Thanks.